The three new criminal laws have come into effect in India. The Bharatiya Nyaya Sanhita, the Bharatiya Nagrik Suraksha Sanhita and the Bharatiya Sakshya Act have replaced the colonial-era Indian Penal Code, Code of Criminal Procedure and the Indian Evidence Act. While legal experts and politicians are divided on what this means for India, let's have a look at how you are likely to be affected. Starting today, citizens can file a first information report online through portal. Additionally, crimes can be reported from outside the city via a zero FIR. The BNSS introduces community service as an alternative to imprisonment for minor offences like theft or defamation, aiming to reduce overcrowding in prisons. However, the law lacks a clear definition of community service, leaving its implementation at the discretion of judges, which may be misplaced, as seen in the recent Pune Porsche case, and the legal twists and turns that have since emerged in the case following the public outrage. Mob lynching is now a distinct offence under the BNS. Murder committed by a group of 5 or more persons on ground of race, caste, sex, place of birth, language, or other biases can result in punishments ranging from 7 years to life imprisonment or even the death penalty. Several civil society groups and opposition parties have critiqued the government, particularly Modi government, over alleged increase in hate crimes and mob lynchings under their power. While the new set of laws have been critiqued for not including marital rape, there's one section that has drawn a lot of concerns, Clause 69 of BNS. Whoever by deceitful means or by making promise to marry to a woman without any intention of fulfilling the same has sexual intercourse with her shall be punished with imprisonment of up to 10 years and also be liable for a fine. Deceitful means includes the false promise of employment or promotion, inducement or marrying after suppressing identity. And this has seen a lot of backlash. But when it comes to marital rape, while I did mention earlier that it's not been included, sexual intercourse with a minor wife has been brought under the ambit of the rape. The IPC had carved out only one exception for marital rape, that's intercourse with wife who's less than age of 15 years. That now has stance changed. So if you have married a wife and there is rape involved, if there's rape involved, that is legally punishable. Trials in absentia, where a person accused of a crime can be tried and convicted in his absence, are another new set of introductions in the BNSS. While such a provision already exists under the UAPA, the burden of proof is reversed in the terror law. That is, the onus is on the accused to prove himself not guilty, rather than the state to prove his guilt. Talking of UAPA, another big decision is the inclusion of offences such as organized crime and terror, with terrorism being defined. Previously, in the ambit of specific stringent laws like Unlawful Activities Prevention Act for Terrorism and state-specific laws such as Makoka in Maharashtra on terrorism, the BNS borrows heavily from the UAPA. Overlapping of laws and jurisdictions being a big challenge. Despite the new laws coming into effect, the opposition has been claiming that the new laws were bulldozed by the government and passed without discussion last year when more than 140 opposition MPs were suspended. Union Home Minister Amit Shah has rubbished the attacks on the opposition and said no laws have been discussed so much as these new laws. In fact, he said 30 hours of discussion were done and 34 members participated in it. Another big bone of contention is, of course, sedition. We'll get into all of these parts. But first, joining me right now, and before I introduce my guest, let's just quickly listen into the reactions.
They will be draconian in their implementation. They have been passed behind the back of Parliament by suspending a record 146 MPs. They do not reflect the collective will and wisdom of Parliament. They also do not reflect the informed dissent of some very eminent members of the Parliamentary Standing Committee on Home Affairs. There are problems with the substance of these laws. the provisions on bail, the manner in which the definition of terrorism has been exculpated into general criminal laws, the loosely defined law with regard to sedition, bringing handcuffs back. So, therefore, there are serious problems which need to be addressed, and that is why these laws need to be paused. They need to come back to Parliament, go to a joint parliamentary committee before they are implemented.
मैं समझती हूँ ये बहुत ही गलत तरीके से ये हाउस में पास हुआ। इन कानूनों में कोई चर्चा भी नहीं हुई है और इस तरह के कानून लाके एक तरह से लोकतंत्र पे जो खतरा पहले से मंडरा रहा था उसमें और जकड़, उसको और बेड़ियों से और जंजीरों से बांधने की तैयारी है। और यहाँ तक कि अगर कोई विदेशों में भी अगर कोई आंदोलन करते हैं अगर अपने राइट्स को लेके तो उन तक में यह कानून लागू होगा। तो मैं समझती हूँ कहीं ना कहीं यह पूरे देशवासियों पे एक शिकंजा कसने की तैयारी है।
लोकसभा में कुल मिलाकर 9 घंटा और 29 मिनट चर्चा हुई है। 34 सदस्यों ने इसके अंदर पार्टिसिपेट किया है। राज्यसभा में 6 घंटा और 70 मिनट चर्चा हुई। 40 सदस्यों ने पार्टिसिपेट किया है। एक ये भी झूठ चलाया जा रहा है कि सबको बाल निकालने के बाद ये बिल लाया गया। बिल बिजनेस एडवाइजरी कमेटी में पहले से निश्चित था। मेरा ये स्पष्ट मानना है कि 14 तारीख से ही विपक्ष ने सदन का बहिष्कार करने जैसी हरकतें करी थी और शायद वो हिस्सा लेना नहीं चाहते थे।
All right, and joining me right now is Mr. Abhishek Manu Singhvi, 3-term MP, CWC member, as well as senior advocate with the Supreme Court. Thank you very much, Abhishek Manu Singhvi, for joining us. My first question, sir, good evening. A lot has been said over the new criminal laws. Even today, as Parliament witnessed a stormy session as they are enforced from today, do you see this as leaving behind a colonial hangover? Well, quite frankly, as the government has been claiming.
In a somewhat lighter vein, let me start by saying that I was aborted in relation to these bills before I was then sabotaged for fourth term in Parliament, which is why I'm not there today in Parliament when these were being discussed. The reason I said aborted was that the day when these bills were to be taken up, I was the designated lead speaker, the opening batsman, so to say. But I obviously did not participate. That was the day 142 people had been suspended, and we all decided not to speak. So I could not unravel the intricacies of the bill as a lead speaker, which I was designated on that day. But on a more serious note, number one, Sneha, if there was any magnanimity, any humility, any acceptance, any recognition of fallibility, which unfortunately is not there, really the government could offer them for a debate again. On any one amendment, the whole thing could be reopened because these have been passed 1,000 provisions, 1,000 provisions in the three with zero scrutiny, no parliamentary discussion. 142 members suspended. That's point one. Point two, it is all very well to talk of colonial mindset, but there's a limit to what you might call cosmetic, not even cosmetic, superficial surgery, and then calling it real surgical skill. 90% or at least 80% of these remain the same.
But let's look at some sections and let's then try and look at whether how much of it is cosmetic or not. There's a lot which is being said about not being strong on marital rape. But how do you look at the clause of sexual intercourse by deceitful means? A lot is being spoken around this as well.
That's in my retrograde category. Very retrograde. You have got this sexual intercourse by deceitful means provision with a very harsh penalty of 10 years. Actually, this is nothing but trying to criminalize what is perceived as love jihad. This is filling an agenda. The numerical numbers of so-called love jihad or mischaracterized love jihad may be there, of course, 1 or 2 or 3 or 4, but it is insignificant and infinitesimal. This provision has been brought in with a very harsh penalty of 10 years. Consenting adults who are retrospectively then going to talk of deceitful sex to be used for community anti-religious feelings about particular communities can be misused hugely. And I would put it very strongly in the negative category of this amendment. It is a substantive amendment. There's nothing to do with marital rape, by the way. Nothing to do with marital rape. Marital rape is not an offense which has come. In fact, the BJP government has been vociferous in opposing it. And I personally would oppose it. No, I personally would oppose it. This is only fulfilling their agenda for love jihad. A mistaken notion, a misleading notion, and a completely misplaced notion which they've done. Then there are very strange things that you have virtually created a anti-terrorism UAPA mini code in the act. You have also created a similar mini code for organized crime like Makoka and Karnataka's Kokoka, etc. Why have parallel? One is the main act, the federal act. And then you have this other acts also having a mini, somewhat modified and lesser, more diluted anti-terrorism and anti-organized crime. Now it's going to be very difficult to choose. You are a police officer, Sneha. You decide to prosecute me under the Sanhitas or under UAPA. It's going to create great confusion.
No, but look at the mob lynching cases, sir, that many would say have been on a rise in India. These new laws now have specific sections in these.
I would say that there is one good provision, a laudable provision of community service. There is a laudable provision of community service. That makes it less penal, more reformative. But you could have done additional reformative things. You did not do, for example, an enhancement significantly of the list of compoundable offenses. Compoundable offenses means you commit a criminal offense, but it is compounded. It need not go for prosecution. It can be settled. You have not done the police reforms required. The heart of our criminal justice system, which is warped, is a low conviction rate. And a low conviction rate is because we have not created Chinese walls between prosecution departments and investigation departments. There are many issues like this. And the worst part in this whole thing is sedition. It is a chicanery, it is a betrayal of the people, it is a betrayal of faith. Remember the sequence about sedition. The matter came to Supreme Court and no less than the Attorney General made a statement that we will reconsider, we are reconsidering, and for the time being, while we are reconsidering, all sedition prosecutions across the country will stop. I hope you remember those orders, Supreme Court orders, one after the other. It therefore was kept in abeyance for 1.5 years. Lo and behold, suddenly out of the blue, a law commission report comes in 2023. The law commission report comes and the government immediately distances itself, saying, no, this is not the government, this is the law commission. As if anybody believed it. And today you have reincarnated, possibly with greater ferocious force, the same sedition provisions, which your Attorney General said is under reconsideration. Reconsideration means repeal, softening, taking away. And here you made it stronger or equal. So most of it is undesirable. Most of it does nothing. It only makes it worse and does nothing for improvement of the criminal justice system. Some of it is laudable. And most of it also is some of it also is a missed opportunity.
All right. No, but would you, Mr. Singhvi, say, as I mentioned about the mob lynching cases, that India has seen a much, it seems to, these cases have been on a rise. So many more cases have been reported than, say, in the past, as it were. Now, these new laws seem to have specific sections on these. How would you see that?
That's positive, but that's not really much relevant, I'll tell you. The problem in mob lynching is always, is rarely ever of the law. Because mob lynching is nothing but another name for murder. The problem is enforcement. What is happening on the ground? Do you think, suppose there was no amendment like the Sanhita, would I punish you very severely for lynching a man on the road? Of course I could. But the problem was that depending on the political dispensation in the state, the police would look at which way the wind is blowing and decide to prosecute or not. Or if they prosecute it, they try and find ways to do a lesser sentence or a simpler sentence. That is that's not a matter of law. That's a matter of the political signal you give. That's a matter of the political signal and the message you give. And it is that messaging which has to stop. Of course, I support a provision which is making it more strengthened about directly and focused about mob lynching. But that provision is no use unless you send a clear message that, look, I may be a BJP ruled state, but you, the police, go flat out. This is a crime against human people. Doesn't matter which religion they belong to. A man transporting cattle for his trade under license with no violation of any, cow slaughter, etc., can't be picked up on suspicion and hanged from the nearest tree and beaten to pulp. That is because there is a Nelsonian blind eye. There is a signal, a message.
Mr. Singhvi, the government says these laws, at the heart of these laws are the fact that there needs to be speedy trial, speedy justice. Do you see that happen with these new laws?
Just the opposite. I'm very sorry, just the opposite. There is nothing here which speeds up the justice process and nothing here which will ensure better and faster and higher rate of conviction. It is just the opposite. Please understand what I'm saying. There is 100 years of case law of Supreme Court and High Courts on the pre-existing laws. They have solidified the meaning, the contours, the boundaries of that law. When you are a judge and a case comes before you on the old law, you know where the law stands because 100 years of High Court and Supreme Court judgments have clarified what each word means. Today, the defense will get up and argue, look, Justice Sneha, 2 words have been changed or 1 comma has been changed in these provisions. All the 100 years of law which is there, wisdom by the Supreme Court must be ignored because that was the old provision. This is the new provision. Please decide all over again. Justice Sneha will probably get it right, deciding all over again the same way as the earlier judgment, but will take much longer because they don't have to simply say, look, there is a judgment, I'm following it. So actually, time will be immeasurably increased and it will lead to slower, less speedier justice, less conviction, not more.
Mr. Abhishek Manu Singhvi, thank you very much for joining us. Thank you very much. All right. And there's always perspectives and there are different perspectives. Let's just get in Abhishek Sudhir, who's an advocate, as well as Aditya Pratap, who's an advocate, and we'll try and get what these laws mean from different prisms. Abhishek Sudhir, to you first. You just heard Abhishek Manu Singhvi. Mr. Abhishek Sudhir, my first question to you. With let's look at what Abhishek Manu Singhvi said about community service. Now, we have the Pune-Porsche case, and we know what's gone completely wrong in that Pune-Porsche case. In fact, it started with a judgment, and what's unraveled since then is a can of worms, if I may use it that way. Now, these laws do not define community service. That is left open for judges to do. How okay is that?
First of all, the Pune-Porsche case is absolutely not covered by the new criminal laws. Please understand that the accused in that case, we don't even call him the accused, we call him a child in conflict with the law. When you're a minor, you're not considered a criminal. You're considered a child in conflict with the law. The Juvenile Justice Act of 2015 governs the actions of the minor in the Pune-Porsche case. Now, if the minor is considered fit to be tried as an adult because the offenses he's committed could possibly be offenses that are heinous in nature, and he's between the ages of 16 and 18, he could be tried as an adult. So, Sneha, I would say that the Pune-Porsche case is not appropriate to be discussed when we are discussing the criminal laws. If I could just build on what Mr. Manu Singhvi was saying, I'm quite confused with what he's actually
Abhishek
trying to
Sudhir,
say.
let me just try and put that question out in a different context. Let me say, for example, one of the furores that really emerged, the public outcry when it happened to the Pune case, was among the different punishments involving the essay writing as well, was the community service. That was also one of the things, and that was, of course, under the JJB. It's a very different aspect, very different connotation. But then you saw about how there was this entire controversy around how could a judge go ahead and give this particular minor who is on the wrong side of the law in this particular case, possibly, allegedly, go and give him community service and then give him the bail orders, you know. So there was this interpretation around the bail orders. Interpretation around community service. Now, does the current criminal laws, do they really define that, or are we open to possibly such interpretations?
Sneha, very rarely do you come across a word in the English language that is not open to interpretation. There is an entire course called statutory interpretation, which I teach, where a single comma makes a difference. There is a difference between may and must. There is a difference between may and shall. Words matter, and every word is open to interpretation. And when I say words matter, I just want to make a larger point today about the new criminal laws because it's a historic day today. Whether one agrees or disagrees with the new criminal laws, we have to acknowledge that after 164 years, we have finally a set of criminal laws that have been made by the people and for the people, by the elected representatives of the people of India. We have a code that is known now as the Bharatiya Nyaya Sanhita. We have done away with the word penal code and we have replaced it with the code of justice. The code of criminal procedure is now called the Bharatiya Nagrik Suraksha Sanhita. We've done away with the word procedure and replaced it with the Suraksha Sanhita, as in Nagrik Suraksha Sanhita, which means protection of the citizens. And you have the Bharatiya Sakshya Adhiniyam, which is the Indian Evidence Act. As an Indian, as a Bharatiya, I feel proud today that the Parliament of India, for the first time in its history, has passed overarching criminal laws. We have finally been able to shed the baggage and the shackles of our colonial past. So words matter. The fact that we today have Bharatiya in the name, a word that has resonance for our citizens, for our culture, and for every Bharatiya, irrespective of his race, religion, or caste. If you live in India, you're a Bharatiya, right? So the laws, first of all, in the words, they matter. And you look at the provisions, if you could just give me 30 seconds, Sneha. It's a historic day because you have the introduction of something known as electronic FIRs, EFIRs. Today, you can sit in the comfort of your own home, and if you're a woman that matters, say you're a victim of rape, you need the help of your family, the people around you, to go to the police station and report the rape. What the new laws introduce is a portal where you can file complaints. It improves women's safety. As the Honorable Home Minister Amit Shah also said, technology has been taken into account. Audio, video recording of all crime scenes has been made mandatory. We already have national forensic universities in 11 states of India. Forensic science is now going to grow. Forensic science is going to be one of the most important disciplines under these new Bharatiya codes. Also, for example, you have a particular time limit. You have to update the person who has filed a complaint on which basis an FIR has been registered. There is a time limit of 90 days on which you have to give an update. There is a lot to be lauded in this new code. We have finally shed our colonial past. Technology has been taken into account. Forensic sciences has been given a very prominent role. So let's not oppose for the sake of opposing. Let's not criticize for the sake of criticizing. Mr. Manu Singhvi, for example, spoke of mob lynching, right? If I could just complete my point with that. The opposition has been crying hoarse about mob lynching. And Mr. Manu Singhvi says, oh, you must send a message to the citizenry that mob lynching will not be permitted in Bharat. And that is the message Prime Minister Modi and Amit Shah are sending to the people of India. How else do you send a strong message?
Let me take this to Aditya Pratap. Let me just take this to Aditya Pratap. Aditya Pratap, Abhishek Sudhir saying that what is this thing about just opposing? Look at mob lynching for that matter. Look at the way these laws seem to acknowledge them in a way that they specifically have sections for them. So isn't that in itself a messaging?
Well, the point is very simple. If you have these acts in one place, why were they passed without any debate or discussion? When such an important law is passed, looking at the entire, which has clear ramifications for society at large, which is a major departure after over 150 years of settled law, why was it passed in such a rash manner with over 150 MPs getting dismissed? In my opinion, you have reduced the number of sections from 511 to 383. You have reduced a lot. You have curtailed the law. But the point is that you still have left several loopholes. Look at the definition of sedition. From it, they have broadened the scope at a time when the Supreme Court actively had said in its settled judgments that the sedition should be narrowed, the scope of sedition. Otherwise, a lot of innocent people will get caught up. I do feel that like a legislation like the IPC, which has been time tested by the Supreme Court, which the Supreme Court has had such a long amount of time to interpret, define. You pass a law without any clear debate or discussion. I do feel that as Mr. Abhishek Manu Singhvi rightly pointed out, as the time passes, the flaws in the act will come into play, because the law and text is one thing, but the law and practice is another.
Can I rebut, please? Yeah.
Abhishek Sudhir, there's also this thing about many people talking that, listen, the change,
Yeah.
you may call it, the terms, the names matter, you said that, but there are others who are saying these are cosmetic changes. You have made it more complex before the courts with the changes in the language, but at the heart of it, there are many that may just about say the same. How would you look at that? Do you really see things change for women and children? I mean, let me ask you this very pointedly. Abhishek Manu Singhvi or other legal experts are very divided whether there's going to be speedy justice. They say they don't see this as a process where it may really be a speedy justice. How do you look at this?
See, let me offer Mr. Pratap a point-by-point rebuttal. He spoke in generalities. First, he said that the new laws were not debated. The new laws were debated for 9 hours and 43 minutes in the Lok Sabha. They were debated for 7 hours and 20 minutes in the Rajya Sabha. If our lawmakers behave like lawbreakers and they stand on tables and throw papers at the chair and then they get suspended, if you do not want to have a discussion, if you treat Parliament like a fish market, then obviously you're going to be suspended. And let's put it this way. These laws were passed in December 2023. The Prime Minister, the Home Minister, the Bharatiya Janata Party went to the people with these new laws. If the people did not want these laws passed, they would have voted them out of power. They've really returned to power for a third consecutive time with a mandate of 295 seats, the National Democratic Alliance. Note the word democratic. So the people have approved these laws. Now,
No, it isn't about passing or not. That's not the point at all.
That is absolutely the point. That is absolutely the point.
The laws are enforced. We're talking about henceforth.
Henceforth, no, that is absolutely the point. The people have had the opportunity to examine these laws. Now, you might say, oh, well, nobody in India leads these laws. I beg to differ. These laws were also an election issue. For example, you had the hit and run provision, which has now been put on hold, right? So if people are unhappy with a certain provision, stakeholders will raise their voices. They went on strike. The Honorable Home Minister said, okay, you have concerns, we will consider these concerns. The truckers and the lorry drivers, right, they unionized and they said, we refuse to go to work until this law is taken off the books, and that provision has not been notified. So these acts are democratic in nature. Sneha, tell me something. If you're a woman and you're a victim of an offense, if today these new laws are giving you a provision to file a complaint on your telephone, on your mobile phone rather, I should say, isn't that making you safe? Isn't that saving you from social stigma? I would urge Mr.
And from
Pratap,
any part of the city.
right?
That's also, by the way, very important. You don't
states
have to be in the geographical jurisdiction.
Absolutely, you don't. You can file the complaint
That's
from
true.
anywhere.
That's true.
Right? And your identity has to be protected by the police. And the audio video, right? Mandating of audio video recording of seizure ensures that planting of evidence will not happen. Another very important point is now the maintenance of a register. Right? The chain of custody of a particular person has to now be recorded at every step of the way. The Congress party ruled this country for the best part of about 5 decades. They've ruled this country. They came to power 98 years after the IPC was
Okay,
passed
I'm
by the
out
British.
of time. Abhishek Sudhir, let me just go to Aditya Pratap for the last answer.
They had the opportunity to change the law. They never did. Yes.
Yeah. Okay. Yes. Aditya Pratap, how would you respond to this whole thing that a person may be kept, a magistrate has the right to increase a person's custody, say, beyond 15 days to whatsoever? I mean, there are concerns that this may lead to custodial custodial torture or whatsoever. Is that a concern? Is that a valid concern?
Absolutely. In addition to custodial torture, I say custodial pressure. Today, under the previous laws, the 14-day limit is the biggest deterrent for any investigating officer, after which the culprit does go into judicial custody. By permitting longer police custody, as I said, that the intentions of the government manifest themselves in the laws it enacts. Today, if you permit detention, police custody for more than the 2-week period, maybe an undefined period, obviously, because in several vexatious cases of private disputes, a person may be kept in police custody and be made to sign an extort and, hand over property from, or acquiesce to certain unreasonable conditions. So I do, when by enacting these laws, on the one hand, the government will say that we have the mandate of the people, it's an election. the point is that, the popular will does not determine one's fundamental and constitutional rights. The three criminal laws, IPC, CRPC, PDF, yes, there have
Just one quick
there
point.
law has been declared by the Supreme Court on so many critical issues pertaining to fundamental rights, and it does appear that in some way the government has sought to weaken the same.
Okay.
Sneha,
Abhishek Sudhir, I am afraid I'm totally out of time.
Just 30 seconds, just 30 seconds. I just want to say,
30 seconds.
Dr.
Go ahead.
Ambedkar said,
Go ahead.
Dr. Ambedkar said laws are only as effective as the people who enforce them, as effective as the people who administer them. He said that this constitution is just a piece of paper unless it is enforced and operated and honored and respected by those who are charged with ensuring that the letter and the spirit of the law is not violated.
All right.
So it is always human beings who will administer these criminal laws. These criminal laws are enforced. I urge Mr. Pratap and his ilk to welcome these laws. I'm a lawyer. He's a lawyer. History has been made today. You can't litigate the past. Let's live in the present and plan for the future.
All right, sir.
Don't give law the color of nationalism.
Okay, Abhishek Sudhir, as all right. Okay, Abhishek Sudhir, Aditya Pratap, thank you very much for a very spirited debate. But nonetheless, these laws are there and these laws have been enforced. I think a lot will need to be required of the citizens to come up to speed with the new terms and the new clauses that are in place. That's going to take some time. Nonetheless, the government is in power for 5 years. It's got the mandate, whatever the mandate may be, in whichever way it may be fractured. They do have the mandate, and therefore they also will be tested by the people in terms of how this is being enforced. Thank you very much, Abhishek Sudhir and Aditya Pratap, for joining us.
Thank you.